Hi everybody. So my name is Joyce, and with me is my wonderful colleague
Michael Yates.
And we are both IP and data privacy specialists here at Taylor Wessing. This training is something that we've delivered in a number of contexts and we've been thinking about for some time. The idea behind it is to sort of give people, particularly IP specialists, but lawyers generally, some thoughts about what we should be doing rather than just advising our clients on with regard to the GDPR and the way that we're operating. And now this is slightly based on some internal training that we've delivered for our own colleagues, but we thought what a great opportunity to throw it out to the broader world. So welcome everyone that's online. I think we might get some questions during the course of this session, and if we do, we will try and answer them as we go along. But if we're not able to, either for timing reasons or because we don't know the answer, which could occasionally happen, then we will try to get back to you subsequently. And so without further ado, I will click on to our very first slide. This, you'll all be delighted to hear, is my responsibility. Michael will not accept liability for the frivolity of this particular slide. But I wanted to start off with us thinking a little bit about data. Because it's easy for us to think, particularly with GDPR compliance, very much sort of has been looming for such a long time now and is part of all of our lives. It's easy to think of data and data privacy issues as being fairly burdensome. Certainly it does create bureaucracy, and it's an area that generates a lot of work for us all, both of a profitable sort for some lawyers like us, but also of a time-consuming sort that takes you away from what you really want to be doing. But the reason that we do all of this is because data is very much the lifeblood of all of our worlds. There are very few of us who operate in a world where data isn't ultimately the most important thing. And so the first two quotes I provided there are, some of my feelings about data in a sort of literary context. But it's the final quote that I want to draw your attention to, because some brilliant private practice lawyer in the last couple of years or so threw this out there.
Might have said it at some point.
I might have said it at some point, repeatedly. And this is very much in line with the idea that, challenges are good and problems are not something that we acknowledge we have. Well, I don't think the GDPR is really a challenge or an opportunity for a lot of people. For many, it is a problem. It is something a hurdle that has to be overcome. But it's not going anywhere, so we have to address it. And the good news is, once we have, actually, by and large, the measures that we put in place and the things that we're aware of do enable us to operate more efficient, better businesses. So it's not all doom and gloom.
So what are we going to be talking about during this webinar? Well, we're going to have a short recap on the GDPR as an intro, and then we're going to drill down into some more specific points for lawyers generally and for IP lawyers particularly, including what's set out there on the slide, so litigation and international transfers, working with third-party agents, legitimate processing in release forms and notices, cyber breaches, mainly in relation to whether an IP claim is possible in relation to those issues, who is searching, hot topic, and subject access requests and the new provisions of those.
Exciting stuff.
So Jo, over to you for a quick recap of the GDPR.
Thank you very much. So the General Data Protection Regulation, we all know it was a long time coming. I feel as if I've been advising on the GDPR for most of my professional life, and that's probably because I have been. The changes that we're seeing are, in some senses, technical. There are new legal obligations, particularly on parties that are processing data, whereas before it was largely just controllers we had to be worrying about. And there are some technical things that we all need to be thinking about that are different under the new regime. However, the real change is one of emphasis. So we are seeing a shift from a world where it's all about previously it was all about being compliant and avoiding being caught out. Now, actually, what's really important under the GDPR is being able to demonstrate that compliance. It's about putting data and data privacy issues at the absolute heart of everything you do. So the principles relating to privacy by default and design are really important, and everything that we do in the context of data, which is, you know, for most of us, all of our work, has to have data privacy somewhere at its core now. And we have to be able to demonstrate that in ways that would previously have seemed absurdly onerous to us. It's not just enough to have your privacy policy in place or to have some training. You've got to make sure it's being consistently updated, that it's easily accessible, and that training is regularly refreshed. You know, in the same way that actually security measures that are good now, in a year's time, our cybersecurity measures may not be sufficient, and we have to be constantly vigilant to ensure that we're, as what's available to us, as you know, both from a problematic sense and a positive sense develops, so too do our own operations. So thinking with a revision hat on about personal data, we have a really broad and expansive understanding of what personal data is. Information relating to an identified or an identifiable natural person, and that can be somebody who's either directly or indirectly identifiable. The new definition is deliberately drawn expansively to capture online profiles of individuals, whether that's, you know, drawn from their browsing activity or other things that are, you know, captured through the use of cookies, which may not identify them by name. But if you can construct a profile of somebody as an individual, regardless of whether or not you can name them from that profile, then you have their personal data, and it needs to be treated as personal data. We're seeing a shift in the territorial scope of the European data privacy regime. It's going to, the GDPR explicitly affects not only those entities that have an establishment in Europe, so a business base in Europe, but also it's for the first time looking to extend the regime to entities which are not based in Europe, but which are processing the personal data of EU individuals, particularly where those are, that processing relates to offering goods or services to those individuals, or monitoring their behaviour. And of course that captures all of our digital platforms, our social media outlets. So hence sort of lots of chat we've seen from the likes of Facebook, Twitter and others around how they are going to comply with the regime, and even those which have very little by way of actual base in Europe still very much need to think about how the new regime is going to impact upon their models. We are seeing, as I already mentioned, a shift in the burden, the regulatory burden, so that as well as those entities which are data controllers, which means that they are both, maybe have actual control of the data, but direct the extent and manner of the processing of that data. And it's always worth bearing in mind here that when we say processing, we really do mean anything. Anything that you're doing with the data, up to and including just storing it on a server somewhere, is processing by the GDPR's definition. So any entity that is directing how and to what extent data is being treated in that way is a controller. The law will now also cover and create responsibilities for parties that are processing data on behalf of other organisations. And those entities will, for the first time, have direct liability to data subjects, to the individuals to whom that personal data relates. And then finally, we have the opportunity to appoint a lead authority. If we're an entity that is captured by the GDPR, which I think we've established is quite a lot of them, you have the chance to choose which of the 28 supervisory authorities across Europe is going to be the one to which you report and generally liaise in order to manage your compliance. What that doesn't mean is that you can ignore the other 27 supervisory authorities. If they receive a directly addressed complaint from an individual to that authority, or there is an infringement which substantially affects data subjects in a particular country, which is not the one in which your lead authority is based, you will probably still have to liaise with other regulatory authorities as well. So we kind of wait to see how much difference the lead authority option really makes.
So I know what's on everyone's mind, and of course it's Brexit.
Hey.
Will we have GDPR in the UK after Brexit, regardless of what that might mean? And I will refrain from doing this slide in my Danny Dyer voice.
For those of you joining us from countries that aren't England, Danny Dyer is a popular actor in the United Kingdom who recently went on a bit of a Brexit-themed rant in a very enjoyable Cockney accent.
There you go. There we go. So, yes, we will have the GDPR until the 29th of March 2019 and up to the end of any transitionary period. Afterwards, will we have a lower baseline of privacy for the UK after Brexit? Well, probably not is the answer, because we will need to have standards in line with the GDPR, because if we have something that's weaker than those obligations, then it becomes problematic for the UK and it becomes less desirable for tech platforms, for example, to do business here, for businesses here to export data into and from the UK, and it will also affect what the EC says in terms of adequacy, because the UK will need to be given an adequacy ruling, and so therefore we will need to do something that's in line with the GDPR. Otherwise, that being provided with an adequacy ruling may cause delays if we don't provide something that's in line. So it's likely that we will have something similar, if not the same, as the GDPR, to essentially mean that we can still be treated as a member state in that respect, in terms of exports to other countries.
Yes, and I think it's worth noting that when it comes to Brexit, one of the very few issues about which the British government has been fairly clear in terms of what's happening post-Brexit is in the matter of data privacy compliance. The government has been explicit that it intends to remain effectively harmonised with the European Union on that point. And hopefully that will encourage the European Commission to offer us a finding of adequacy without too much of a delay. Now, just quite how that works, of course, remains to be seen.
Just moving on to the...
Oh, we have a question. Should we answer the question,
Michael?
Oh, if you
want to answer the question. Yeah.
We did promise that we would look at questions we went through, or rather I promised, and Michael sat here and just took it. And the question is about applicability. So the GDPR says that it applies to individuals in the EU. Should we assume that means not only EU residents, but also tourists and visitors as well? Well, my advice on this point is to make as expansive an assumption as you can. The thrust of the GDPR and one of the things behind it is that if in doubt, assume that you're liable in court. There is a lack of specificity about exactly what makes you a relevant data subject, but if you are processing data within Europe, then it should be treated in the same way. And if you are processing data outside of Europe and you are not sure the exact status of the individuals in question, but there is a reasonable chance that they are based in the EU or passing through the EU in some sense, then I would strongly advise treating them as if they are captured and their data is captured by the regulation. Anything else is likely to lead to some form of fairly lengthy dispute before the CJEU, which no one really wants to get into, in my view.
Thank you, Joe. So moving on to the key rights for data subjects while we finish off this recap section. And remembering that data subject is a very broad term, no change there. May include external counsel or clients or customers or colleagues, and even infringers when we're talking about IP. But more on that later. So just zipping through the subject access rights remains, and we'll be talking about that later on in the talk. The right of erasure, not the band, or the right to be forgotten, as it's called post-Google Spain. So that's the data subject has the right if the data is no longer necessary, or he or she withdraws consent or objects, or if there are no legitimate grounds for processing, or if processing is unlawful. And it's worth noting that that right extends now beyond just search engines, as the decision in Google Spain decided. So it can be quite a powerful right, but it is a qualified right because it requires a balancing exercise to be undertaken in relation to the processors or the data controller's freedom of expression, and if that freedom of expression right outweighs the data subject's right to be forgotten, then it cannot be asserted, and it's subject to other public interest processing exemptions such as public health, archiving, and legal claims as well. The right of data portability, transferring data from one data controller to another. The right of rectification, and this applies to data that is inaccurate, and a data subject can require a data controller to complete incompleted data. Restriction of processing, the right to object, and that's where processing is taking place on the basis of either consent or on the basis of another legitimate interest. A data subject can object if processing is taking place on those bases, and that essentially amounts to withdrawal of consent, requiring the data controller to stop, unless the data controller can show compelling legitimate grounds which override that right. So again, it's that balancing. It's a qualified right, similar to the right to be forgotten. And lastly, the right to prevent direct marketing. So just on the subject of infringers, what if you are processing an infringer's data? Is it all over? Can you no longer do that in relation to infringer? Can they cause problems for you? Well, the answer is that there is an exemption in Article 21 and to some extent in Article 23, which provides that you can continue to process personal data of an infringer and other third parties in the establishment, exercise or defence of legal claims, even where they object. But that doesn't mean that you can process the data however you like. You still have to be fair and proportionate. So there is some derogation there in relation to infringers on the basis of processing for legal claims, but it still has to be fair and proportionate. Anything to add, Joyce?
No, I think, well, the only point I would say is on the fair and proportionate side, it's hard to know in practice what that's actually going to look like, and I think the point to make there is that it's really going to depend. It's going to be something to consider probably on a case-by-case basis. If you are dealing with large amounts of personal data, particularly if that data is sensitive in nature that relates to an individual or a group of individuals who are perhaps potential defendants in litigation, it is important to have the front of your mind the fact that their rights as data subjects are, continue to exist regardless of the fact that you're investigating them for some form of wrongdoing. We'll cover this a little bit more when we talk about dealing with third-party agents and inquiry agents, that sort of thing, which some of us do from time to time. But the fact that you have this exemption and it enables you to process in many circumstances doesn't just mean you can do whatever you want. The other principles in relation to data minimization, only collecting what you need, only storing what you need, and keeping information only for as long as necessary, those will all continue to apply in every context.
So now we're going to move on to the more specific areas for IP lawyers that we identified at the beginning, now that the recap is finished. And the first one of those is international transfers. So under the GDPR, the general prohibition on personal data transfers outside the EEA remains. So that any transfer to a country outside the EEA, there must be a valid mechanism, an adequacy mechanism to get round that, and that can apply to anyone who's deemed to be adequate by the European Commission. The Commission can deem a territory or an international organisation or even a sector as adequate, which means that transfers can be made without falling foul of the provisions. Important to remember that the US is not deemed to be adequate by the European Commission, and so those who are transferring to the US have to rely on the Privacy Shield, which I'm sure everyone is aware of. So an entity signed up to the Privacy Shield is protected. But it's worth noting that, like Safe Harbour before it, the Privacy Shield is under attack, and it may be that falls at some point in the same way that Safe Harbour has done.
Yes, so we're looking quite closely at the moment with some interest at how Privacy Shield is being threatened through litigation, and indeed at European level more generally. One of the issues of some concern is around the fact that actually a lot of it's about the appeal mechanism and the management mechanism for Privacy Shield, and there is an extent to which attacks upon that could actually also seriously impede the ongoing validity of standard contractual clauses, which are sort of moderated and handled through a similar mechanism. So there is a appreciable risk that we could end up without any adequacy, any ways of determining adequacy for transfers to, say, the United States. Now, it is quite hard for a country to obtain a general finding of adequacy, and we touched on this with regard to the UK, because post-Brexit this is something that we will need to achieve in the United Kingdom. A number of jurisdictions do enjoy such a finding. Canada is a good example. Japan has recently received one, so it is possible, but we see very little chance that any of the 50 US jurisdictions are likely to be in line to receive one. So we will continue to need to rely upon either Privacy Shield or standard contractual clauses in order to make transfers. For intergroup transfers as well, there are, of course, binding corporate rules which are a favourite and often incorporated as part of an intergroup agreement, which we're seeing a lot of at the moment. So there are a number of mechanisms for making this happen. What of course all of this doesn't mean is that once you have your legal mechanism in place, you forget your technical measures. And in fact, we would strongly encourage people to really pay attention at the moment to the technical and security measures they're putting in place with regard to transfers, because if there is a legal issue around the ability to safely transfer because there's a successful attack upon, say, Privacy Shield, you want to know that if it's business critical that you continue to transfer data regardless of that lack of finding, that at least you have secure measures in place to minimise the risk that you could be faced with a breach of something of that sort.
There are some questions coming in, but we'll deal with those in a second. Thank you again for the questions. We'll deal with those shortly. Just while we're on the subject of international transfers, as an example, what is Taylor Wessing doing as IP lawyers, as data privacy lawyers? Just on the slide there, we set that out, putting in place the intergroup agreements that Joe was just talking about, in place to deal with transfers between our various legal entities in different jurisdictions, which involve entities outside the EEA. Every transfer should be as secure as possible, and secure means encrypted or password protected as appropriate. But what does that mean, Joe?
Well, and this is an interesting point, because it really depends upon the nature of the data and the nature of the transaction. So we have to think about internal transfers of our own employee data when we're moving that around, but also we are a controller in respect to the data that we're moving around for our clients as a general rule, because of the way in which we are regulated. We in most law firms need to be controllers of data because we have to ensure that we are processing it with our own direction. So we could potentially be moving quite large amounts of sensitive data around if we're doing it for transactional reasons. For example, where we're dealing with cross-border issues that our employment teams are handling, they may have lots of data on employees of clients and third parties. So depending on the nature of the data, the volumes of it, and to whom it has to go and where, we may well be uploading it to secure data rooms and ensuring that we have restrictions in place on who can access that. In some cases, it may be appropriate to send data in a different format. It might be an encrypted spreadsheet. What we won't be doing is sending lots of hard copy documents by courier in the way that we used to in the good old days, and similarly, sort of unencrypted memory sticks that I don't think we've ever sent around to the firm, but certainly you occasionally become aware of them being moved around in the industry. That sort of thing that really would not be acceptable anymore. So it's a case of thinking about what's appropriate in the given circumstances and making sure that as well as the general need for security, because obviously we have confidential information as part of these transfers, we're also thinking about the rights of the data subjects as well as the interests of our clients when we're moving this around.
Okay. Consent in contractual and quasi-contractual arrangements, Jo?
Yes. So this is an interesting one for, and this is an issue that's come up for us both actually, because we both have practices which span intellectual property, reputation management and data privacy type issues. So we are quite often asked to look at things relating to release forms, documents that relate to image rights and that sort of thing. And previously, you would have a situation where you would see a release form which would include normally a confirmatory assignment of IP rights, a waiver of moral rights, and a consent to processing from the data subject. And those documents were always interesting because sometimes they would be contractual documents, so it would be a situation where the individual was being paid for their appearance. Sometimes it's not a contractual document, it's a situation where you've obtained a waiver from an employee to appear as part of an advertising campaign. And you're not paying them separately to their normal remuneration as an employee, so it doesn't really fit that bill. And we've previously thought, well, consent's great in that situation because we can't rely upon this document as being a contract, and obviously contractual need to process data is one of the legal bases for processing. But if you didn't have that, then you say, right, well, you get their consent and that's fine. The problem we're facing now is that consent can't be implied and must be explicit. So you have to make sure that your wording is right there. And more worrying than that, in addition to it needing to be explicit, specific and informed, there is a presumption that consent can always be revoked. And for that reason, consent, in this context at least, is going out of fashion. We don't want to seek consent in many cases if we can avoid it. Sometimes it is the most appropriate mechanism for obtaining the right to process data, and we can't avoid that, and we shouldn't. But in many situations, we actually need to look and see, well, is it in fact a legitimate interest basis? Are we saying that we as an organisation have a legitimate interest in processing this data? And are we entitled to rely on that? So what we're generally advising, depending on the circumstances, is that where we're obtaining waivers, whether it's a standalone document or part of a broader contractual position or information notice, is that we need to make it clear if IP and moral rights are being transferred or waived. That's right and proper. But we shouldn't be seeking consent to process the data. The obvious exceptions to that being where we're dealing with children under the age of 16, or in some member states 13, depending on how national legislation has derogated or not from the regulation. And in those cases, we still would advise obtaining consent from a parent or guardian. Obviously, other local provisions may apply in relation to those circumstances. Now, this is in many ways challenging because what we can't do is say, well, we're going to treat this as a situation where legitimate interests apply. We're going to process the data without consent. That's all fine. We won't mention it, because despite the fact that you are not relying upon consent, the transparency requirements of the GDPR and the obligation to explain to individuals what it is you're doing with their data, where you're getting it from, how long you're going to keep it, who will have access to it. Those things all continue to apply. And where you're going to be processing data, you do need to make it clear to individuals what you're doing. So it's a bit of a delicate balancing act between drafting clauses that make it clear to individuals what you're doing with their information, but also being explicit as to whether or not you're actually seeking their consent to do it. And you may have to really spell it out in some cases to ensure that you are processing on the right legal basis. One of the reasons that this is so important to get right is because the regulation and all the guidance we've seen around it from the Article 29 Working Party and local regulators, all of that guidance makes it clear that there should only ever be one legal basis for processing data for any specific processing activity. So if one falls down, you can't just say, well, that's fine, then I'm going to rely on legitimate interest now if this contractual provision doesn't hold up, or vice versa. So once you've picked one, you have to stick with it. And that's why it's important to make sure that these drafting arrangements work. Because if you've decided that actually, if the data subject thinks that they are providing consent for processing, then it's going to be very hard to deny them the right to revoke that consent, even if you thought actually, no, this is a contractual arrangement. So it's going to take some time to get that right, I think, for some people.
And we've got some questions. Is now a good time
to
address these? So thank you again for the questions. Question 1, does actual content covered by IP, such as photographs, constitute personal data? The answer to that is yes.
Yes, it does. Absolutely. If you can identify them as an individual, then it's personal data.
It's also worth mentioning that, just because it's also an IP right and personal data can span lots of different things. A defamatory statement can be personal data. Private information or confidential information can also be personal data. So because it's got such a broad definition, it does span a lot of different areas. Question 2, is the Data Protection Act 2018 geared towards ensuring that the GDPR will remain applicable to the UK post-Brexit?
Great question.
I don't know if anyone has read the Data Protection Act 2018 yet, but it's a little bit like someone threw an ordered series of papers up into the air and then stuck them back together at random.
Yeah.
And it is a great read, although slightly confusing.
All 339 pages of it. You may judge from the tone of voice that Michael and I are adopting that it's not our favourite piece of legislation.
It's even worse than the 1998 Act. Which,
I quite liked the 1998
Act. Yeah, once you got the hang of it.
Once you got the hang of it, that is true. So I have a great deal of respect for the parliamentary draftspeople. I think they do a wonderful job. I think this is not our finest hour. The Act is designed to incorporate the GDPR as much as possible into national law. It's interesting because the GDPR will effectively form part of the acquis, the existing legislation, which we will simply absorb into national law at the date of Brexit. But the Act actually does seek to specifically incorporate aspects of the GDPR and to try and import it wholesale into national statute, whilst also including some derogations, and in some cases bits of gold plating as well. So whilst for the most part what we're going to see is the GDPR forming the basis of law, there is also tinkering around the edges to try and make it more UK specific. It is an essential read for us all, but not an easy one. And there are, I think, 20 schedules, possibly 21 schedules, she says, flicking through it. So it's going to take some time to get to grips with this particular piece of legislation. I would strongly advise anyone who's coming to this as a relatively new area to start with the GDPR, start with the regulation. Most of that is applicable in all 28 member states, and when you get to more nitty-gritty questions and more granular issues, then only to look at national legislation. I mean, the UK is actually ahead of the game, astonishingly, in terms of having legislation on the statute books. Germany was unsurprisingly first. there with a fairly decent bit of legislation, followed by the Austrians, and then we had a bit of a rush. So I think I'm not sure whether we managed to get ours on the books before Ireland did, but it was all around the 23rd, 24th of May that a number of countries finally got their stuff out. But we are still waiting. Some other jurisdictions have not produced derogations. The important point to note is that because it's a regulation, it has direct effect. So even if you're in a member state which hasn't produced any new legislation of its own around this area, the GDPR will have effect as if it were national law in those places.
Thank you. Question 3 from a listener in Brazil.
Ooh.
Hello. If a European individual is based outside the EU for work purposes, does this company in this country comply with GDPR if in some way the company sends its employees information among the company's group, which include a company in Europe?
European individual based outside the EU for work purposes. So if companies in Europe are processing that data, then they need to ensure that they are treating it in a manner that is compliant with the GDPR. The extent that European individuals are based outside the EU and their data is being processed by entities outside the EU, in theory, no, that shouldn't. I mean, obviously, other local laws may apply, but the GDPR shouldn't capture that. But to the extent that an EU company within the group is processing that data, they need to ensure they're doing so in a compliant manner. Now, actually, for their purposes, that should be relatively straightforward. If they are accessing the data rather than transferring it out, then they need just to make sure that the manner in which it's stored and dealt with is compliant, which shouldn't be too challenging because it should be along the lines of the way in which they're processing all personal data if they're using the same systems. It's only if they then are processing data and sending it onwards that there's an issue potentially.
And question 4, the US is included in the list of non-EEA countries deemed to have acceptable data privacy standards for processing data. Does that only refer to organisations that are compliant with the EU-US Privacy Shield or any entity in the US?
Yes, so only organisations which are which have signed up to and met the requirements of Privacy Shield will be presumed adequate, because the general position in the US is with regard to the US is that it doesn't meet the necessary data standards as far as the European Commission is concerned. That said, there may well be other mechanisms employed, such as an adherence to binding corporate rules or an intergroup agreement with standard contractual clauses adopted, which means that individual organisations which aren't signed up to Privacy Shield can still be deemed to be adequate, or can still argue that they are GDPR compliant and seek to demonstrate that. What those arrangements don't generally have is a sort of quasi-governmental seal of approval of the sort that you get from Privacy Shield, but for the most part, if I see an organisation has signed up to the standard contractual clauses and has a schedule in place which details sufficient security measures, then I would consider that to be sufficient for most transferring purposes.
So what you're saying is there are a number of different routes that one can be compliant. But that doesn't mean that it's every entity in the US. They have to either be compliant or have binding corporate rules, or be signed up to Privacy Shield.
Exactly,
right.
So, yeah.
Okay. All right. Thank you for those questions. Keep them coming if there are any more. Moving on to working with third parties and investigation agents and other firms. This is obviously what a lot of different companies and businesses do. Particularly if you're trying to identify third parties or an infringer or what have you. And the important point here is to remember who is in charge. If you share data with third parties, you are going to be doing that either as an agent or as a data controller in your own right. In that regard, responsibilities fall upon you. You become responsible for the actions of your appointed processors. So, i.e. the investigation agents or the third parties. You're also responsible for ensuring that you have written terms in place with those processes you engage. You have to be sure that there is a lawful basis for processing both by you and your appointed agents, so your appointed processor. You have to make sure that adequate security measures are in place, both of the transfers between you and the processor and at the processor's end, so between that processor and anyone else. It's important to remember that this includes hard copy documents as well that are organised sufficiently, and that data in the public domain is also caught. There's obviously no public domain exception to the obligations under the GDPR.
I think that's a really important point, actually, because we often see people often conflate the obligations under the GDPR and data privacy laws generally with those in terms of that apply to commercial data of commercial value or private information. So the kind of breach of confidence, misuse of confidential information, or private information cases that Michael and I often deal with. In addition to our data privacy work, and they are different tests. The fact that information is out there in the public domain is normally a barrier to pursuing a breach of confidence claim, unless the whole point is that you're pursuing someone for putting it in the public domain. Whereas where you're talking about personal data, the fact that it might be available and exist in a number of different places, the fact that someone might have put information about themselves on their own website or on their own Facebook page, for example, these things do not in themselves mean that you can then take that information and process it. It does slightly alleviate the problems in relation to special categories of data or sensitive data. If the data subject has manifestly made information about their religion or political views public, then you commenting on them or doing things with that information is less likely to be a serious breach with regard to sensitive personal data, which is held to a higher standard. But it doesn't mean that you can just compile a database that includes a load of private information about somebody without making them aware of it and giving them the opportunity to object to it. So the existence of information in the public domain is really, this surprises a lot of people as well, which is why I'm trying to emphasise it a bit, because it really is an easy way to be caught out.
In relation to subject access requests in this regard, if you receive one from a data subject you have investigated, you may have to disclose the details of the investigation to that data subject. And this is more likely if you've not undertaken the appropriate risk assessments to ensure that you have an appropriate legal basis for processing that person's data. So it's always important to remember that data you are processing could one day be provided in some shape or form to the target of that investigation, and it is always best to keep that in mind when processing and engaging agents.
Yeah, and any decent inquiry agent should really be aware of this now, and it should inform the type of information they're seeking, the methods they're using to collect information, and the form in which they provide that data to you. And where you're dealing with particularly sensitive information, it may be essential to deal with some of this face-to-face or over the phone rather than having written reports which could be circulated more broadly than they ought to be, all of which activity is generating more and more liability.
Okay, and there's a couple more questions, but I think we'll come back to those in a sec. Mm-hmm. In the meantime, moving on to the next slide. It's worth just mentioning IP in relation to cyber breaches and data protection. Under the GDPR, companies that suffer a cyber attack or a data loss will have a mandatory breach reporting requirement, whereby they've got to report that breach to the ICO within 72 hours where feasible after becoming aware of that breach. And of course, the second main obligation in that regard is to notify the data subjects who are affected by that breach, unless the data controller is exempt under Article 34(3) of the GDPR. So, for example, if the information has already been encrypted, or if the risk is no longer there, or if it would be disproportionate to inform all of the data subjects. But it's important also, I think, to note in relation to cyber breaches and obviously the repercussions, increased obligations under the GDPR in this new regime, that there is an evolving area of jurisprudence in this area whereby the courts have been willing to allow victims of cyber attacks who've been blackmailed to obtain injunctions against those hackers, usually defined in these cases as persons unknown, because obviously you don't know who they are, or if you do, then they're not a particularly effective hacker. The court has been willing to grant these types of orders to companies who suffer those types of issues. And it's important to mention the basis upon which I think the court has been granting these injunctions. There's two on the slide there, one of which we were involved in ourselves. And the court has been granting these orders on the basis that the information that has been stolen by the hacker has been confidential. So the claim has been based on a cause of action under the law of breach of confidence, on the basis that the information was confidential, it had a necessary quality of confidence, and under the case law that says that there is an obligation of confidence on someone who unlawfully or illegally extracts information via hacking. And you may say, well, so what? You get this order, what good is that against the hacker? And the real answer to that question is this, is that once you've obtained your injunction, you serve it on your hacker, but the order has a penal notice on the front of it, and it also has provisions that any third party put on notice of the order should comply with the order in its interim form. And the beauty of that is that if the blackmail victim, usually a company, refuses to pay the ransom, the hacker then tends to go on a disclosure spree, posting the company's confidential information here, there and everywhere, online, on platforms, on download platforms, on social media, to carry through the threat that was originally given. And the purpose of the order, once it's served upon all those platforms and third parties, is that 9 times out of 10 they comply and they remove the information. So you're essentially cutting off the circulation of the hacker's threat and cutting off the effectiveness of the blackmail, having information, confidential information posted online, incrementally taken down to protect the company to the point where usually the hacker gets bored and moves on to the next target. Why am I mentioning this here? Well, I'm mentioning it because there, of course, are some limits to obtaining an injunction on the basis of breach of confidence, and that's mainly that it's not currently law in this country that one can obtain a blocking injunction against an ISP in a claim for breach of confidence, where of course it is possible now under the 97A jurisdiction in copyright, and now following the Court of Appeal decision in Cartier in relation to trademarks, to obtain blocking injunctions against ISPs, whereby you're essentially going higher up the publication or distribution chain. You're not tackling the website, you're cutting users off from the source, i.e. the internet service provider who provides them with access to the internet. And so it's always worth remembering or considering in a cyber breach incident what exactly has been taken and where you think the hacker may post or distribute that information. If you think that said hacker might put that information on websites which will not comply with an English court order, perhaps in rogue jurisdictions or whatever, you may want to consider obtaining an order if the information that's been stolen is actually intellectual property or copyright, because that may enable you to go higher up the chain and cut access off at the source from the entry point of the ISP rather than the website itself. So it's important to remember that with an IP right in a cyber breach incident, you potentially have a much stronger ability to diffuse a hacker's threat than perhaps you would under a claim for breach of confidence. And it's also worth noting that the case that we were involved in, action was taken in several European jurisdictions, and in those European jurisdictions, the basis of those claims against the hosts and to go in and get an order to freeze the information that had been uploaded and for an order for delivery up were all based on intellectual property claims. So it's important to bear that in mind when dealing with a cyber breach.
Okay, so before we move on to the next section, which is talking about a little bit about who is searching and the problems of that, I'll tackle a couple of the questions that we had in a little earlier on talking about privacy shield and standard contractual clauses. So there's one query asking if potential issues with STCs, are they going to be updated? Because of course the standard contractual clauses are based on, well, they are as drafted pre-GDPR. And then a further query relating to the relationship between Privacy Shield and other forms of data protection agreements. If a US company is not Privacy Shield certified, or if that goes away, can that company agree to the standard contractual clauses in a data protection agreement in order to process the EU data? Well, so we are at some point anticipating updates to the SDCs, standard contractual clauses, but for the time being, those are considered to be sufficient, and we don't need to do anything to them. As many of you will know, we have to be careful about the extent to which we update those clauses or vary them. They are standard for a reason, so you will normally see them appended to a broader framework agreement or either intergroup or multi-party agreement in order to flesh those out a bit with having some more front-end detail. In terms of the relationship between those and Privacy Shield, well, I talked a little bit about some of the challenges that's going on at the moment. Many of you will remember the Schrems litigation, which did for Safe Harbour some time ago now, Privacy Shield being its successor. Mr. Schrems, because he loves a bit of litigation, he is an Austrian citizen who filed the initial claim against Facebook in Ireland. He has doubled down on this, and we have new, well, not that new now, but as of 2017, litigation was filed again against Facebook in Ireland, arguing that Privacy Shield and standard contractual clauses, which are used by Facebook to move data around in and out of the EU, are inadequate, and there is an argument that depending on the decision, and this was referred from the Irish High Courts up to the CJEU, depending on how that decision is framed there and how specific that decision is, it could ultimately knock out both Privacy Shield and standard contractual clauses as options for transferring data to the US. The reason for that is that Mr. Schrems' argument is that there is nothing in either mechanism, either the Privacy Shield mechanism or the standard clauses, which will protect you against US intelligence agency overreach. So whilst both will give you a cause of action against any recipient entity which doesn't properly care for data in the manner that they should, it doesn't help data subjects whose data is inappropriately accessed by government agencies. So there is a possibility that both of those options will be knocked out. I would say that whilst Privacy Shield has its benefits, for the most part I would recommend using the standard contractual clauses as an approach because they will cover you for many jurisdictions, beyond just the United States, and Privacy Shield only applies in the US. And there is, I think, a reasonable chance, so this is largely my speculation, that even if standard contractual clauses are not viewed as adequate as a transfer mechanism for moving data in and out of the United States, that doesn't necessarily mean they will be considered invalid as a mechanism for transferring data in other jurisdictions. We may get to a situation where we have to look at it on a case-by-case basis. Which is challenging if your business needs to move data in and out of the United States, but nonetheless we'll monitor that and further updates to come. just to sort of bring us to a nearer conclusion, I'm going to talk very briefly about who is searching, just for a touch of something entirely different, because this is something that we deal with both as litigators and as part of our work in managing IP transactions. We've noticed, some of you may have noticed that if you conduct a WHOIS search, so a search to identify the individual who's registered a particular domain name, that a lot less information is coming up than used to. For some reason, ICANN, the International Corporation for Assigned Names and Numbers, the organisation that manages domain name administration, did not fully appreciate that it was not going to have the benefit of an exemption under the GDPR, and the information that it publishes about individuals obtaining domains and all that it permits to be published through WHOIS searching was not going to apply. This became apparent in October of last year, 2017, and after a mere 5 months or so, ICANN CEO wrote to each of Europe's 28 data protection agencies asking what to do and seeking some form of special exemption. That did not work. The ICANN statement, which came out stating that actually significantly less WHOIS data would be available from the 25th of May than was the case previously, was something that would have to be accepted. And there is the option for ICANN to put forth an accreditation model to enable registrars to create a mechanism whereby easier searching and more detail can take place, but so far nothing has been proposed, and I checked this yesterday and we're still waiting on that. So for now, significantly limited amounts of data compared to what we used to are available for WHOIS searching. Now, this doesn't sound like such a big deal, but it actually can have quite wide-reaching implications, particularly for transactional work where there's a lot of domain names to be considered and potential liability associated with them. In terms of litigation, where you're dealing with a domain name that is hosting unacceptable content or is problematic for other reasons, it's often the case that those will already be hidden by proxy services, but not always. And previously, we have been able to obtain all sorts of surprising information about people who are infringing through content they've put on websites they've registered, and that data is now obscured. More interesting, I think, is corporate transactions, and we have found that a lot of organisations are not aware that we cannot simply run the usual searches that you would as part of a due diligence exercise in order to verify domain names. This means that we're having to flag this up at an early stage and ask people either to provide evidence that they have the registrations, which also may mean that evidence that it's registered in the company name and not the name of an employee, which is a very common situation. And that may require additional warranties to be provided as well to ensure that actually, if somebody is made redundant as part of some form of corporate transaction, they can't walk away with domain names associated with one of the company's bigger brands, for example, which is a situation that I, believe it or not, have in fact seen. So this all, if you're dealing with large transactions, this is the sort of thing that needs to be dealt with at the early scoping process to ensure that adequate time is allowed to gather the necessary information.
Right, and just to conclude, subject access requests. So what are the new rules, and are they different to Section 7 of the DPA 1998? So the new provisions are in Article 15 of the GDPR, which set out the right of access for data subjects, and the restrictions to that right are set out in Article 23, and then in Schedules 2, Parts 2, 3 and 4 of the DPA 2018. Good luck with finding those. So the provisions themselves are set out in a more granular way, more granular broken down detail, which is quite different to Section 7. And you'll see Article 15(1)(a) to G, which set out all the different pieces there, Jo. comments on those?
I will. So it's always been the case that if an individual made a subject access request, or a request for information about what sort of personal data a controller holds on them, they had to be told what categories of data were there, what the purpose of the processing was, who the recipients or categories of recipients would be, whether there was any automated decision making taking place, and if so, what the criterion or logic surrounding how that decision making took place was. And they had the right to be provided with readable data in most circumstances for their own consultation. Within that, a number of other things were implied, but the new regulation and national legislation makes it more explicit that individuals have a right to know the source of the data. They have a right to understand what the safeguards which have been put in place around that data are, particularly with regard to international transfers. There's also a slightly confusing aspect to Article 15, which says that they have the right to be told that they have the right to complain to a supervisory authority, and a right to request rectification, erasure or restriction of processing. Now, it's not clear whether if you are answering a fairly straightforward and specific question that a data subject asks you, whether you are also expected to provide that sort of information as well. And that's a little bit unhelpful, because any request that an individual makes about their information, and they do not need to refer to the legislation in any way, should be treated as a subject access request for the purpose of the regime. My general recommendation around that is that you answer specific questions where they're put, but you also direct individuals to a privacy policy or compliance statement that you will hopefully have available, which would set out who the data controller was, where they should go for further information, and would probably also reference the right to complain to a supervisory authority if their query wasn't answered by the organisation in question, rather than necessarily treating every inquiry received as a very full request, which requires you to undergo lots of searching and provide lots of information that the individual may simply not want.
So other main changes are an individual can make a subject access request verbally or in writing. So verbally is certainly one to watch out for.
Yeah.
You have less time than you did before. You have 1 month from the date of the request rather than 40 days. You can no longer charge a fee to deal with a request in most cases, and you can only refuse to comply with the request, and that's in addition to obviously the restrictions to the right, if it's manifestly unfounded or excessive. But watch out for the jurisprudence on this, as all of the pre-GDPR jurisprudence has really only been pushing the power of the data subject's right of access further and further forward, be it when it clashes with legal professional privilege or abuse of process arguments. It really is a very, very powerful but specific right, and yes, it can be used for pre-action disclosure or disclosure really at any point during a piece of litigation, and it needs to be considered carefully.
And that's a really important point. The motivation of an individual when they make a subject access request is entirely irrelevant. As Mike says, the only situation in which you can refuse entirely to comply is where it's a manifestly unfounded or excessive request, and the current guidance suggests that really will only apply to cases where there have been repeated claims put in, where there has been no substantive change from one request to the next. It's certainly a problem for a lot of organisations, and the fact that you can make what many of us would view as a very unreasonable request, a very burdensome request, is not considered relevant for the purpose of whether you have to reply. And it is important to know that even if you are going to refuse to provide data or information or responses on the basis that an exemption applies, and that might be, for example, that there is legal professional privilege in place or litigation privilege, which means that you are not obliged to disclose certain details around the data or the processing. That doesn't mean that you can just ignore the request. You still have to make a response in most cases, even if that is to say, yes, we are processing data on with relation to you. No, we're not going to disclose it because an exemption applies. So you cannot simply ignore them, which is another mistake that I think a lot of organisations make, particularly those that aren't used to dealing with these, which is the case for a lot of businesses that are operating outside of the EU that have never been obliged to handle them before. So it can be a thorny area. They can be expensive and challenging, and we are certainly looking to see whether we have a bit of an uptick in litigation around these as well. Previously, people would just complain to the regulator, but there is a serious aspect of the GDPR which encourages people to bring group litigation, and so this is one area of potential error or failure to adhere to the GDPR, where we think that there will be claims management companies seeking to sign up lots of individuals to pursue organisations on this basis. So that's definitely one to watch out for.
Right, and that comes to the end of our talk. We've got two further questions here. So the first one, on ownership of IP developed with personal data embedded, what disputes do you envisage on this? Well, I've got a good example here that I've been thinking about whilst I've been reading this question, and in the media space, an example might be a paparazzi photographer who took a photograph of somebody, i.e. they would own the copyright in the photograph, but the photograph would be of an individual who has data subject rights, and that data subject may not want to have had their photograph taken, and may try and assert their right of erasure or their right to object, one of those kind of rights in relation to the photographs, and on the basis that the photograph contains personal data. I can see a clash between the photographer's rights, ownership of copyright, and a clash against the data subject's rights. And I think that's certainly an example which I could envision. I'm not quite sure where or how a court would go about dealing with that kind of issue. I'm sure a court would perhaps consider the public interest. I mean, there is a public interest defence in copyright. There are obviously balancing factors to be undertaken when assessing a right of erasure or right to object, and it could be that the court might consider that the IP right was an overriding interest in relation to the data subject's rights.
I doubt it.
Right,
it could.
But it could be, but at the same time, I think the court would probably take into account all the circumstances and the processing involved, and whether the photograph was then sold to a national newspaper and published online and all the rest of it. I think there are a whole can of worms there, which certainly I'm looking forward to getting involved in.
And what's going to be interesting is a lot of these cases are going to be fact specific, so it's not very easy to generalise, and largely that's because a lot of it's going to relate to what was the data subject told at the point at which their data was captured. So were they provided with information about what was going to be done with their data, and if so, how clear was that? Were they made aware that it might be sold on, for example, to another organisation, an agency, Getty Images, whomever it might be, and that information then used more broadly. Even if they were informed of that, was what they were told specific enough, and was it still fair to treat that data in that way? And of course, that particularly if we're talking about consent and reliance upon consent, they can't. Consent is not considered valid unless it is informed and specific. So unless you were informed of what was going to be done with your personal data at the time that image was captured, and you expressly consented to it, then the
which is highly unlikely.
Which is highly unlikely in a lot of these cases, and that which is one of the reasons why we're arguing people avoid consent. But even if you've avoided consent entirely, you still need to be transparent about the nature of the processing that's going to take place, and that is very difficult in some of these cases where you simply don't know how widely reaching an image is going to become. So there are, I think Michael's exactly right when he says that we're going to have to see some interesting case law and some principles building up around this area, but a lot of it's going to be fact specific, which is a real challenge, I think, for organisations which base their models around movement of data and images in particular.
I think it might come up if a photograph has been published and it is no longer private because it is in the public domain.
Yeah.
Someone would seek to assert their data subject rights in relation to processing rather than publication.
Yeah.
But it'd be interesting to hear from anyone out there in relation to any kind of other disputes that they might envisage with a clash between IP and DPA. And finally, the last question, we have found that our agents in other countries are not very forthcoming in signing and returning SCCs. Do you have any good practice to help with this?
It's interesting because I've seen a real mix of this, and it depends on your bargaining power to a certain extent. In some areas of business and for some types of operation, you will find that actually, if you simply say, well, we're not going to instruct you unless you sign this, because the liability accruing to a controller who passes data to a processor that they don't have written processing terms with is significant. The other point I think that is worth making as well is that if those agents, if those organisations are processing data in relation to European data subjects, or are processing data within Europe relating to any data subject, they have liability as well now. And they may not be aware of that, so it is always worth actually giving them a bit of a summary of what their obligations are and their risks to the data subject, because if they are processing on your behalf and they sign up to terms that you have provided to them and they only process the data in accordance with those terms and on your instructions, then they are largely protected from risk and liability. It's only if they diverge from your instructions or they do something which is quite evidently not lawful or not appropriate processing that they will then be at risk themselves. So it is actually strongly in the interest of processors to sign up to these terms, which are standard terms and therefore should not be too controversial. And I think maybe flipping it round and trying to explain to them that there's a real benefit to them in having this contractual protection as well is a method worth trying. But I do sympathise because it is not an easy conversation to have with organisations which simply don't understand why they're suddenly being asked to do this. So I'm afraid, good luck. Good luck and try and sell it as a benefit would be my recommendation.
With that, thank you very much indeed. Any further questions, feel free to get in contact. And from Joe and I, thank you very much.
Thank you and goodbye.